Sana.
Most obliged.
Good afternoon, Jacob.
Good afternoon, sir.
My name is Evans Misati. I'm a member of this selection panel. Karibu sana.
Thank you very much.
So, Mr. Muvengei, allow us the honor of getting to know you, and perhaps briefly just tell us why you are interested in this position, why you are the best fit, as you introduce yourself.
Thank you very much, Chairman and distinguished panelists. My name is Jacob Ngwele Muvengei. I'm 47 years old, come from Kitui County, and an advocate of the High Court of Kenya. This is my 18th year of practice as an advocate of the High Court. Upon my admission to the bar, I briefly worked for a period of 3 years as an associate advocate in a law firm by the name Gadia Mushero, where I was a senior associate specializing in an area of law we refer to as litigation, which is basically dispute resolution. Having worked there for a period of 3 years, I saw an advertisement by Parliamentary Service Commission where they were requiring to recruit clerk assistants. I took the initiative, I applied, and I was fortunate among the 20 who were recruited. So I joined in, that is the year 2009, as a clerk assistant. I know this panel being secretariat by Parliament, you understand clearly that the clerk of Parliament is assisted at his technical level with officers who carry the title clerk assistant, so that there's no confusion in the title of clerk. So upon joining Parliamentary Service Commission as a clerk assistant, I was deployed in the Directorate of Committee Services. In the Directorate of Committee Services, I was assigned duties in 2 committees. First, I was assigned duties as the clerk in charge of the Committee on Delegated Legislation. I was fortunate because ordinarily in Parliament, they don't assign what we refer to as rookies or monos to undertake those duties of supporting or being the head of the secretariat of a committee. And again, I was also assigned to a committee, a departmental committee. By then, it used to have the name Departmental Committee on Energy and Information, where again, after a period of around 6 months, together with a colleague of mine, whom we had joined together, we were fortunate again to be designated as the lead clerks, which was also an honor of having accorded to us who are the entrants. So at the Committee on Delegated Legislation, this was a new committee in our jurisdiction. We did not have a parliamentary mechanism to scrutinize development of legislations, subsidiary legislations in Kenya. The committee had already been established, but having been appointed as the head of the secretariat, the technical advisor to the committee, my chairlady at the time was Basandamina Abdallah. We realized that there were gaps in terms of the standing orders were not adequate. They were not clear enough in terms of how the committee will be able to discharge its mandate. And we also established that there was also gaps at the national legislation, which provided the national legal framework for development of subsidiary legislations in Kenya. Having established that, I assisted the committee to come up with amendments to the standing orders. I drafted the standing orders, and these standing orders are the ones which are still now in the standing orders of the National Assembly, which were also adopted in the standing orders of the Senate. And with the advent of the county governments, those same standing orders are the ones which are applicable to all the county assemblies in Kenya. Basically, these are the model standing order which I assisted the committee to develop. With respect to the issues of national legal framework, we in the committee, assisting the committee and the technical advice of the committee came to the opinion that there was need to develop a standalone legislation which will facilitate a whole encompassing legislation to assist in the scrutiny of statutory instruments in Kenya. So for that reason, I drafted for the committee a law by the name Statutory Instruments Act. That is the law which now governs the development, scrutiny of subsidiary legislations in Kenya. Well, still at the Committee on Delegated Legislation, around the year 2012, since the Elections Act provides that all the electoral regulations must first of all be submitted to Parliament for pre-approval, we in the committee were assigned the duties of reviewing the regulations, which were supposed to midwife the elections which was coming in 2013. It took a while before the regulations were submitted to Parliament. In fact, my experience in that regulation is that I had to walk all the way to Anniversary Towers and literally came carrying those regulations because it was in November, around October, and that there was a set timelines when the regulations are supposed to be developed. So with that having been tabled, in the Joint Committee of Delegated Legislation and Legal Affairs, I worked together with my colleagues and also officers from the IC to review those regulations. We drafted them for a period of 5 days. And of course, they were done in a hurry, so we had to do 80% of the work. That was my first engagement with electoral laws. We drafted the elections regulations, general regulations. We also drafted the voter registration regulations, and we also drafted the dispute resolution regulations. These are the regulations which were passed on time to assist on midwife the elections. Chair?
Do you want to proceed with your introduction so that we deal with your introduction before your achievements?
So,
yeah,
okay, I can, so basically I can say,
so you had reached at clerk assistant after
after working as a clerk assistant, I was deployed in the legal department in Parliament, where I rose through the ranks as a senior legal counsel, and eventually by the time I left Parliament, I was a principal legal counsel. Chair, in the year 2013, I applied and was appointed as a founding clerk of Nairobi County Assembly. I was sent there as an interim clerk, and I was the one who was supposed to start and develop the county assembly. So that was also the path, I worked there for a period of 9 years. And afterwards, I left the assembly in the year 2022, after the new government had come into place, and there were challenges which, given opportunity later, I'll be able to explain. And I was supposed to, given the circumstances, I was either supposed to go back or start my legal practice. For that purpose, I decided to open my law firm, where I am now as a managing partner. I'm also a consultant. I also run a consultancy firm called the Legislative Center, where also I am the managing partner dealing with the issues of legislative development. For the last 2 years, I've also been the legal advisor to the governor of Isiolo County. So, Chair, back to your question, the reason why I believe that I'm suitable to become the chairman of IEBC is that, based on my experience, I have a well-rounded qualifications, both as a political manager. I also have legislative experience. I also have public finance management and administration experience. And I'm also a lawyer of a period of 18 years, so therefore I have legal experience to be an effective chairman of IEBC.
As a legal advisor to the governor of Isiolo County, is that a civil service job or it's a consultancy? What is it? It
was a contract job which whose term has ended, which has already come to an end. It's a political appointment. Legal advisors are not per se within the scheme of service of the basically governor's officers within the governor's office. So we work under the chief of staff, and we are not in the mainstream county public service. But my contract has come to an end.
But you draw a salary?
Yes, we draw salaries and allowances.
And at the same time, you're running a law firm?
No, because these are part-time jobs. All the political advisors are part-time jobs. They're not full-time officers.
Okay.
Yes.
Thank you. Madam Linda.
Thank you, Chairman. Mr. Ngwele Muvengei. Now, apart from your professional legal background, which we are aware that you are well grounded, looking at the documents that are before us, and your experience as an advocate of 18 years standing, apart from that, do you have any other skills, competencies, and disciplines outside the legal profession that you intend to use if you become the chairman of the IEBC in your administration?
Yes, thank you very much, my learned counsel. I believe that I possess around 5 skill sets, which makes me an ideal candidate to become the chairman of IBC. Based on the experience, having worked in parliament, having worked in the county government, I possess political management experience. I believe that the chairman of IBC, the IBC is a political institution. The IBC is an institution which midwives and which assists in midwifing the political process in the country. Therefore, the IBC requires a chairman who possesses political management experience to assist the commission navigate the political landscape and also in stakeholder engagement with the politicians. Apart from the public, who are also one of the clients for the IBC, the other stakeholder for IBC are the political actors. And therefore, a chairman of IBC requires to possess political management experience. And having worked in national parliament, having worked in the County Assembly of Nairobi, which is a politically charged institution, both of them are politically charged institutions, have developed skill sets and experiences which, if I become the chairman of IBC, I will be able to assist the commission achieve in its stakeholder engagement and navigate the political landscape. The other skill and experience which I bring to the table is public management and administration experience. I've been an accounting officer for a period of over 8 years. I've been an accounting officer of Nairobi County Assembly. Nairobi County Assembly is the largest county assembly in Kenya. Out of the 49 legislatures in Kenya, if you count Senate and the 47 county assemblies, Nairobi County Assembly is the second largest legislature in Kenya. I've been the accounting officer for that particular institution, and during my tenure in the county assembly, when I went to the county assembly and I was sent by the transition authority to establish the assembly, there were no institutions. I came from parliament. When I landed in City Hall, there were no institutions. The only thing which I went there with was Article 177 of the Constitution, together with the sergeants at arms, officers in this, who serve the assembly. So I had to build the institution from the scratch. At that period of time, I had only 1 month to swear in the members of the county assembly. So upon landing in City Hall, unlike other assemblies in the country who are lucky and privileged to have inherited established structures, that is, all the county assemblies were supposed to inherit the municipal structures, that is, the county government structure, staff, and the buildings. Nairobi County Assembly did not inherit any. All the facilities, the staff, and the employees were transited to the executive arm. So having landed there, I had a period of 1 month to swear in members of the county assembly. And within that 1 month, and there were 127 members. That is the largest number of MCAs in the country. Of course, the second one is almost 90. So upon swearing in the members, I had to build the structures. The first one was the county assembly structure, which is a constitutional body. I had to assist in the establishment of the county assembly. That is the political side of the assembly.
So what skill is that?
So this skill is a public finance management and administration skill.
Okay.
And with that particular skill, just a follow-up on that skill, the county assembly is a mirror of national assembly. So they have to be the body which is responsible for the day-to-day providing services and facilities and oversight of the administration of the assembly. It's called the County Assembly Service Board. I also had to establish the County Assembly Service Board, where I became the secretary of the board. So here I was the procedural advisor and also the secretary of the board. Upon the board coming into place, I established the structure of the county assembly. We did not have the organizational structure for the institution. So I came up with the organizational structure. I assisted the board in recruitment of officers. I personally, because of my vast experience in National Assembly, I participated in building the capacity of these officers, developed the manuals, and the regulations which govern the services. So, Chairman, this demonstrates that I possess administrative experience. In terms of the public finance management structure, experience is that the Assembly did not have any building. The Assembly did not have any offices. The Assembly did not have a chamber. The Assembly did not have a committee room. It had zero. And I brought a proposal to the board, and having brought the proposal to the board, we agreed that we needed to build a new chamber. We did not have a chamber. The chamber we were supposed to inherit was actually the old council chamber, which could only accommodate 60 MCAs. But here we were 127 MCAs, and then this house ought to function. What we did is I identified a building, an abandoned, disused facility within the city hall. It used to be a movie theater. So within a period of 3 years, within a period of 2 years, with a budget of 600 million, I was able to remodel that movie theater into an assembly chamber, equipped with modern, ultra-modern digital multimedia congress system. From that project, Chair, I'm proud to inform this panel that we made a saving of 70 million, and we did not use any consultant. I requested the county secretary to second technical officers from the executive who assisted in the project. That project, Chair, has never raised any single audit query. That project was never investigated, has never raised any criminal or any malpractice in terms of procurement. We delivered it on time, paid all the contractors, and we never had pending bills. So, Chairman, this demonstrates my public finance management experience. I believe that IBC requires a chairman who has got practical experience. Even though procurement is the preserve of the technical officers in the IEBC, the IEBC requires a chairman who has got hands-on experience, who can guide and assist the commission in implementing its procurement processes.
So you have mentioned 4?
I've mentioned 2. That is, the other one, Chairman, is the legislative experience.
Okay.
So I've dealt with the political experience, political management experience.
Public administration and finance.
Public administration and finance. Public finance management and administration.
Legislation.
The legislative experience.
Then next.
The legislative experience, maybe, Chairman, if you allow me, the legislative experience is very critical. Yeah. Throughout the period of time I've served both in the county assembly and in Nairobi and parliament. I refer myself as a legislative expert. I've drafted laws both at the county government and the national level. Even what I do nowadays, in my consultancy, I draft policies for national government agencies. I draft bills for county governments and county government agencies. So I have the requisite legislative experience. Chairman, the IBC, right now, there are legislations which are pending approval by the Commission. I'm aware that the IBC has got around 4 bills which are waiting approval. I'm also aware that the IBC has got around 8 regulations which are waiting the Commission to come on office. It's therefore imperative that the IBC should have a chairman or a member who appreciates the legislative development process. And I believe that a skill set which will be very useful in the IBC. Lastly, Chairman, as an advocate of the High Court for the period of 18 years, I've appeared in courts. I call myself a dispute resolution expert. I've argued cases in all levels of courts. I've argued precedent-setting cases. I'm well-grounded in the areas of law. I believe that the legal requirement for a chairman of IBC should a person who possesses the experience, or the qualification of a judge of the Supreme Court. Chairman, I believe that I have that experience that I can offer the IBC. Chairman, as you are well aware, the IBC is one of the most legally regulated institutions. It has very many laws which govern its operations. It has many regulations. IBC also participates, IBC is also supposed in its mandate to resolve the issues of settlement of political party disputes. I believe with my experience as a lawyer, I'll be able to assist the commission and get the members in the legal, how to navigate in the legal minefield and resolve the disputes which will be coming before the committee.
Thank you, Mr. Ngwele, for that explanation. Now, tell this panel Out of your experience in and in your journey, in your career journey so far, has your leadership skills been tried and tested? And if so, please explain to this panel how such an experience has occurred throughout you in some time in your journey, in your career journey, especially in instances where you've had high pressure work, because you know during the electoral period, the IEBC commissioners and the chairperson usually find themselves in a very high, intense, politically, political environment that has different actors, and some of which you have seen in the previous elections, 2022, 2017, 2013, how it has been, including 2007 when we had the post-election violence. How has, in your journey, in your career journey, how have you been affected, and how has your leadership been tested? Please explain to this panel.
Thank you very much, Wakili. From the period in which I became the clerk of Nairobi County Assembly, everybody knows that Nairobi County Assembly is one of the most high pressure and heated legislatures in the country. And for you to be the clerk of the county assembly, you have to develop certain attributes which will assist you to navigate the politics of the day. And navigating political challenges was part of my day-to-day processes. So by the time I left the assembly, I'd already built the ability to navigate through high pressure processes, and had to build in myself certain values. One was an element of fidelity to the law, that as long as you stand by the law, you'll never find yourself in problems. The other one was I had to develop personal attributes. One of it was on conflict management and consensus builder. When you sit between members of the county assembly, you are the neutral person. You've got no interest. You're not aligned to any of the political formation, and for that reason, you have to gain the confidence of the politician so that they can trust your advice. If you are a partisan person, they'll never gain the trust of your advice. And from that, I emerged as a leader in the Nairobi County. And of course, throughout the process, I encountered challenges. My biggest challenge was in 2017, when now the county assemblies were being sworn in. Under the law, that is the election law, the elections of the speaker is supposed to be conducted by the clerk of the county assembly. Basically, the clerk of the county assembly is the returning officer in the elections of the speaker. That is under the Elections Act and the standing orders. In 2017, I was the one who swore in the members. And before I went to swear in the members, the governor had already gazetted the swearing of the members. Around 8:30, I received a call, and I was told to go to the county governor's office. There was an urgent meeting. When I went to the office, I got into a room, dressed and robed, ready to go to the chamber to swear in members. I found a collection of members, leaders from parliament, senate, even my political leaders. And the issue at the table was that the list of the nominated members had been gazetted earlier, a few days earlier, and according to the discussions on the table, some members had been sneaked in. So the request for me was to delay or to stop the swearing-in ceremony and the elections of the speaker. Yet it is a statutory function. There I was standing, and these were the mightier of political heavyweights in the country. So I stood there. One of the leaders looked at me and told me, kindly use wisdom. So at that particular time, I told the members that the gazettement has already been effected, that the swearing-in must be conducted. And the time of swearing-in has already been gazetted as 9 a.m. The only way you can stop the swearing-in is by production of a court order. Of course, the argument was that there was a court order going round. I demanded for the court order. I told them, using my political management experience, I told them, this is the law, but I can only stop when you produce the court order. So the best I can do as a consensus builder, I'll go to the chamber, see the standing order allow you as a speaker, because of the speaker of the day, to adjourn the sitting so that I can allow the court order to be produced. So I told them I'm going to go to the house, I'm going to invoke the powers of Speaker of the day, because knowledge of a court order as a lawyer, and you know it very well, that you can be in contempt of court when you're aware of existence of court order and you've gone against the court order. So I assigned one of my legal counsels to go with the court and assist to get the court order. I called after 1 hour. She told me they have not even gone anywhere. So there was actually no court order. So without reference to the political leadership, I walked, I led the procession to the house. I saw the members. I saw in the members. I conducted the election with the speaker. And when I was walking out, the leadership came and met me and they told me, you are a lawyer. So I was basically able to navigate that process through the fidelity to the law and through my political management skills, which I've gained over a period of time. Thank you.
Thank you very much, Mr. Ngwele. Back to you, Chairman. Thank you.
Now we will ask Carol Kituku to ask you some questions.
Thank you so much, Chairman. Good afternoon, Mr. Muvengei.
Good afternoon, Council.
Let's have a quick conversation on, now that you identify yourself as an expert on dispute resolution, let's have a conversation on that area. Have you been involved in any way in resolution of electoral disputes in Kenya using the court system?
Not at all. Although I've worked with a colleague of mine, that is Dr. Muvengei, I've worked on him in the background in the elections petition that he has been handling as his advisor. But not in the technical appearance in the court, but I've been working with Dr. Muvengei in the petitions. I've worked with him with the petition which was for the last election petition. I also worked with him. So that the reason why I worked with him also wanted to learn.
Which one is this? The presidential,
this
gubernatorial, which one?
Yeah, this is the presidential petition.
Okay.
Yes.
All right. So let's pick it up from there. So what is your understanding of the mandate of the IEBC in regard to dispute resolution of the electoral matters?
Thank you very much, our council. The mandate of IEBC with respect to resolution of dispute matters is anchored in the Constitution. Under Article 88(4), the IEBC is given the mandate to resolve electoral disputes. And also within the Constitution, the IEBC is supposed to resolve electoral disputes relating the pre-elections electoral disputes relating to nominations. That is disputes arising from or relating to nominations. That is the constitutional mandate of IEBC in terms of dispute resolution. And of course, within the Elections Act, now this process now is further enacted, and IEBC has developed, and I was part of the process which came up with those regulations. These are now the rules and procedure of dispute resolution of 2012, which, when I was a clerk of the delegated legislation, I assisted in the development. So IEBC is tasked with resolving disputes arising from and relating to nomination, but all the disputes post-elections, they go to the election petition courts.
At what time do we say that the mandate of the IEBC is over and the mandate of the court starts? What triggers that?
The declaration of results. The minute the results are declared and a candidate is declared and is given the relevant certificate, then now the mandate of the election court kicks in.
Okay. So let's go back again to the IEBC. Does it have any other mandate for dispute resolution outside the nomination process within the electoral cycle?
Yes. IEBC also, there's an issue of code of conduct. Article 84 of the Constitution requires any candidate standing for elections to comply with the code of conduct. That is the political party and the candidates to comply with the code of conduct prescribed by the IEBC. Therefore, IEBC under the Elections Act, I think it's in the schedule, it has prescribed the code of conduct of candidates and political parties during the electoral period. That is after the gazettement of the election period until the votes are declared. So the issues of code of conduct and this mandate arises from Article 86, that is Article 81, which requires that an election, free and fair elections, free from intimidation, threats, undue influence, and corruption.
So, Council, what is the specific mandate then, therefore, of the IBC? I understand what the law says, so I am just interested to have a conversation on how and does the IBC get involved in dispute resolution outside the nomination processes. This is, you understand the electoral cycle.
Yeah.
So within the electoral cycle, from pre, during, and post. So let's go to pre, right? Pre-nomination. Does IBC have any mandate there?
What we need to understand is the period which is prescribed by law is electoral period. Electoral period is a period after gazettement and declaration of elections. So that entire period of time, of course, the IBC will announce the period for nomination. So the issues of primaries, the issues relating to primaries, of course, are preserved of the IBC, but they have been transferred to the political parties dispute tribunal. Then now leaves the IBC to deal with the issues of nomination per se. That is where a person is challenged. But
okay.
Back to your question, the issue of code of conduct requires the IBC to have a committee at the national level which is supposed to deal with the issue of enforcement of code of conduct.
So I was particularly getting interested in hearing your views on how the IBC resolves any dispute that are raised outside the political arena by the politicians. Can a voter have a dispute that can be raised by the IBC to the IBC? Let's say, for example, issues on voter registration, omissions, incorrect information. How does IBC resolve such disputes when they come to its attention?
Those ones are now, I cannot refer to them as dispute resolutions contemplated by the Constitution, but these are administrative issues. If it's a question of voter registration, because if the question of relating to the voter registration, then this is an administration complaint. But the kind of disputes I'm referring to are quasi-legal disputes.
Okay, let's move on to the issue of the IBC now and its mandate in the electoral petitions, in the election petitions now. So many a times, and when actually it's not many a times, it is the law that wherever there's an election petition, in whichever form, MCA, gubernatorial, MP, member of parliament, president, the IBC is always named as a respondent in those petitions. I would like to hear your views on what you think about that and whether it should be an issue of law reform, in the sense that when IBC is named as a respondent, it ought to take a certain position in the petition, right? And the person who has gone to court challenging for, let's take an example of the presidential petition. The person who has gone to court challenging the validity of the declaration of the results is aggrieved. And IBC, being the body that was the referee, comes to court and takes a position to defend the person it declared as the winner. So I am just interested philosophically in understanding whether or not that should be the correct legal position, in the sense that it was a referee of the contest of these two people, the person who was declared the winner and the person who is now challenging that validity of that declaration. Should IBC not take a neutral position, in your view?
Yeah,
what do you think?
Thank you very much, Wakili. And as part of my review of what, if I'm given the opportunity to become the chairman of IBC, in the course of preparation for this interview and also familiarizing myself with the elections laws and everything, I've identified areas of law reform. And that is one of the provisions which I had concerned with, because in my legal practice as an advocate, it is the party who chooses the parties. It is not the law which chooses the parties, because some of these petitions are disputes between a candidate and a candidate. So then, why would you then bring in the IBC in a dispute whereby, unless it's only the candidate who has got a specific complaint against the IBC in terms of how it conducted the elections, how it breached the law, then you should make the IBC as a respondent. But an automatic enjoining of IBC by law in all electoral petitions, whether they're for MCAs or anybody, when the IBC has got no stake, has got no claim in that petition, I don't think it is a proper, it's proper, and the same ought to be relooked at, because it has an issue of costs. The biggest, one of the largest, that is the highest expenditure in legal services for IBC post-elections is payment of lawyers of their legal fees. And you know very well, as a lawyer in your practice, if you are brought in court, you're entitled to your fees. So that one also has an impact in terms of the IBC budgets. So that is an area which needs to be looked at when you're effecting, if I'm granted the opportunity to be the chairperson of IBC, using my legislative experience, legislative drafting experience, that is one of the issues I'll assist the commission to address.
All right, I hear you. So I am more keen on the neutrality of the IBC, because we cannot ignore the fact that IBC ought to be a part in the proceedings. But my concern is, what role does it ought to play? Because does it disadvantage the person who is in court to challenge, and gives an advantage to the person whose validity is being questioned, in the sense that IBC has taken a position that whatever it did, it's defending that, and the court is, I mean, it's that in Kenya, the processes we use is adversarial, right? So the court is not doing an inquisitory, it's adversarial. So that is my thinking, that, and I agree with you to a certain extent that there should be reform issues. Now to the last question. We have this animal called party hopping in Kenya, where a candidate is lost at, or rather loses a nomination and moves to a different party. Or during the lifetime of the term they're serving, they change parties or are seen to promote ideological ideas of another party. What do you think the IBC should come in and help in such instances? What is the mandate, or what is the role of the IBC in that regard?
And I understand that your question has got two components. One is pre-election period, and the other one is during the electoral period, isn't it? Of course, the one during pre-election period is an issue of concern to political parties. It's one of the issues which was raised in ADCO in its own recommendation, whereby the political parties want an element of political discipline in when people are already elected in a political party. You need to remain in that political party. The minute you espouse the policies of, or you make public declaration, or you change parties in between, then you've lost the sponsorship of the party which sponsored you. In other jurisdictions, you lose your position, you lose your seat. Although here it's written in law, but it's not implemented. So NADCO, in one of the recommendations, they have recommended, they even want to constitutionalize that issue. In the report, if you look at it, that issue wants to be elevated at the constitutional amendment level, so that there's a constitutional prescription against party hopping once you have been elected. But during the electoral period, before the nomination, before the nomination is over, the issue which arises most of them is the issues of becoming an independent or running to another party. It runs counter. If you prescribe a bar on that one, it will definitely run counter against Article 38, has got the right to vie. Because unless you cannot block a person, if maybe was rigged out in this particular nomination, then that particular person still has the constitutional right to vie in another party. But it's the question of the question of party membership also applies. Can you change your party membership at the last hour? But the constitutional rider on Article 38 will still play. But I think that is an issue to be provided for in the Political Parties Act.
So you've raised another triggers my concern. when somebody, as you say, has been rigged out at the party primaries and they become independent candidates, does that in any way promote democracy? And raise any concerns? Like at one point you were a member of a certain political party, then you did not get the certificate for nomination, then you designed from that party and then become an independent candidate. How does that sit within a democratic state?
Of course, the right to be an independent candidate is a constitutional provision. I think that is Article 85, which provides...
Sorry,
back to your question.
I am asking in light of the fact that you were not independent from the very beginning.
Yes.
You were associated with a certain political ideology of a certain political party. But because it did not go the way you wanted for one reason or another, now you come back, now you want to be independent.
Of course, it does not augur well in a democratic setup. What as IEBC needs to do as a regulator of nominations, what the Constitution has prescribed as a function of IEBC and the guiding principles of an electoral system, the IEBC is supposed to regulate nominations. So what IEBC should do, and I'm granted the opportunity to be the chairperson, that's an issue which I'm going to deal with, is to straighten up the issues of political parties nomination. We need to deal with the issues of political parties nomination because nominations are the first stage to an election. And in some instances, there are constituencies whereby if you win nomination, you've become an automatic, you have won the elections, basically. The election day is basically a crowning moment. So what IEBC needs to do, and based on my experience in terms of law reform and legislation, is to implement the component of IEBC which requires to draft the guidelines for nomination. IEBC needs to step forward, number one, to frame clear guidelines on election nominations. Number two is also to police the election nominations so that we can build confidence. Part of this confidence deficit, people are talking about IEBC and elections as a whole, is how shambolic way in which political parties are conducting their political parties nomination. So if IEBC is able to come up with clear framework, because there's nobody else granted the same mandate in the Constitution other than IEBC, then we'll stop this process of party hopping. You will lose your elections and the nomination, you will concede, and we'll move on and wait for the next election. But as long as the political parties, there are no clear guidelines, the conduct of elections, nominations is still in doubt, then we'll always experience that challenge, which is not good for democracy.
All right, thank you very much, Mr. Muvengei. All the best, and thank you, Chairman.
Thank you, Caro. After a glass of water, we will ask Dr. Koki Muli to engage you briefly.
Good afternoon again.
Kitu naitwa linganisha. Hii mtu